Good evening, everyone. I'm Ankit, and you're watching the Indian Express analysis, which goes live every day on 4 p.m. at StudyIQ IAS English. Now, in today's discussion, we are going to discuss important articles from today's Indian Express newspaper. That are these 6 articles, and we'll start off with the National Judicial Appointment Commission. Now, this is a constitutional body which was brought by the government under 99th Constitutional Amendment Act back in 2015. But we saw the Supreme Court of India actually held that this particular amendment of the Constitution was unconstitutional and void. Now, as there is a controversy regarding the conduct of a High Court judge, so therefore there are demands that such National Judicial Appointment Commission, which had participation of both judiciary and executive in the matters of appointment to both Supreme Court and High Court, should be again established. So we are going to understand once again how the appointment process takes place. I will try to emphasize more on National Judicial Appointment Commission, as only last week on 22nd of March I dealt in detail about the current ongoing process of judicial appointment, that is the collegium system. Now, these kind of articles, these are relevant from GS paper 2 syllabus, because structure and functioning of judiciary is a part of your polity syllabus, right? And in the second article, we are going to understand about the Economic Advisory Council of the Prime Minister of India, as the former Director of ED has now been appointed as a full-time member of PM EAC. So we'll try to understand what kind of a body is this, what kind of functions does this body exhibit in its day-to-day functioning. All of this is important from GS paper 2 syllabus, because regulatory, statutory, non-statutory, constitutional bodies, these are given in the GS paper 2 syllabus. Then in the third article, we are going to understand how the revised criteria for classifying MSMEs have been developed. The government in its union budget this year on February the 1st announced that it is going to revise the criteria for defining MSMEs, that there are separate definitions for micro, small and medium enterprises. So we are going to understand how this has been changed. In addition to that, we are also going to understand what are the benefits that the government usually provides to MSMEs in order to make things easier for them, be it regulatory benefits, be it financial benefits. We are going to take up in our today's discussion. Then the places in news, we are going to discuss the Black Sea, because recently Ukraine and Russia, they have agreed to stop their war, particularly in the region of Black Sea, and also attacking each other's infrastructural and energy related projects. So this brings our attention again to Black Sea, and we have seen that the coastal bodies, water bodies, etc., that have been in news are important from exams perspective. Case in point, last year's prelim, there was this question on Red Sea, and we know Red Sea was in news due to the attacks going on the Israel by the other 3H of the region, that is Hamas, Houthi as well as the Hezbollah. So that is why Red Sea was in news. Now Black Sea is in news, so we are going to understand how and what are the geographical features of the Black Sea. Then in the fifth discussion, we are going to understand that Rushikonda beach has been given the certificate of blue flag tag. How a beach qualifies to be given a certificate of blue flag tag? Are there other beaches in India that have similar certification? We are going to understand that, in addition to which kind of a body gives away this kind of an award. Now, this is important from GS paper 3, that is the environmental perspective, okay? And in the last article, we are going to have a detailed discussion on the phenomenon of bulldozer justice, because we have seen in the last few years there has been a trend going on in the state governments particularly, that in addition to judicial punishments, the accused of severe crimes, particularly law enforcement problems, those accused have been delivered a form of bulldozer justice, where their offices, their homes have been destroyed on the pretext of illegal construction, encroachment, etc. So we are going to understand the legality of bulldozer justice. Is it a right form of justice, or there is some issue regarding to it? Also, we are going to solve a question on this particular topic. Understood? Now, the notes of this session will be available as usual on my Telegram channel, ATS Live. So you have an option to go to my Telegram channel. This will, this is the word that you have to search on my Telegram channel, ATS Live. It will take you directly to the channel. Subscribe to it, and also if you can't find it, even that, way, you have an option to scan this QR code. Please do subscribe to the channel. I give you regular updates on that, and also the questions that we attempt on a day-to-day basis. You can submit your answers on that particular group if you want me to evaluate such answers. Now, I understand right now there is an atmosphere of prelims going on, so the overall encouragement for you to write mains answer are quite less. But please understand the fact that clearing prelims is not just enough for you to get your name in the final PDF that is released by UPSC. You also have to clear prelims, but you also have to make sure to have a good answer writing command, so that eventually when you appear in the mains exam, you have less problems and you are able to qualify mains examination with flying colors. So for that, daily answer writing, something which only takes about 15 minutes to half an hour of a day, but it will pay you rich dividends going forward. So please pay close attention to this. This is the question that we are going to take up. Critically examine the legal, constitutional and ethical implications of extra legal demolitions in India. Suggest measures to ensure that the governance mechanisms adhere to principles of justice and fairness. So this kind of a question, you have to understand, you not just have to write from a legal perspective but also an ethical perspective, because overall on a broader point of view, it tests your ethical knowledge, whether you are able to dissect this news from various dimensions, from various domain, and summarize everything beautifully in a 250 worded answer. That is the challenge. I'm sure most of you know the bare details about this particular issue, whether this is good or bad, you have it in your mind, but to be able to put that thought in your answer writing is something very crucial, and very less people have that ability. So please inculcate that ability. Now, let us start our today's discussion with this first article. This article appeared in the explain section and also in the op-ed section. The article is written by the former Attorney General of India, and this article on explain beautifully highlights the argument which favors the resurrection of National Judicial Appointment Commission. Now, I told you structure and functioning of judiciary is a part of GS paper 2 syllabus, and the pages where this news was given is on page 11 and 16 respectively. Now, the context of this discussion is that recently we heard that there is a row over discovery of wads of currency notes at the official residence of a Delhi High Court judge, Yashwant Verma, last week. Now, this has given reason to a debate that the judicial appointment process right now, which is overtaken by the collegium system, it is in a way opaque and less transparent system. So why not just have the judiciary to be responsible for appointment? Why not just take the help of executive also? And therefore, Vice President of India, Mr. Jagdeep Dhankar, has referred that National Judicial Appointment Commission Act, which was passed by Parliament back in 2014, had this in place, this would have given the government of the day a greater say on who to appoint as the member of Supreme Court, or as a judge of Supreme Court, or as a judge of High Court. So this has given reason to the debate of NJAC. Now, in this regard, let us quickly understand how the appointment process happens in the Supreme Court and High Court. For Supreme Court of India, the appointment happens through Article 124 of the Constitution. And if you read this Article 124 of the Constitution, it says that there shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 other judges until a Parliament by law decides a larger number. So every judge of Supreme Court of India shall be appointed by the President by warrant under his hand and seal, after consultation with such judges of the Supreme Court and the High Court in the states as President may deem necessary. Similarly, if you look at the appointment process for judges of High Court in Article 217, it also says that every judge of High Court shall be appointed by President after consultation with Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than Chief Justice, the Chief Justice of that High Court. So the moot point of this article, or both of these articles, is the word consultation here. Understood? So what is consultation? Is just mere asking the opinion of the judges, mere consultation, or legally binding directions of the government or of the judges to the government? Is it consultation? This was the subject of question. Now, this was not a subject of question right at the time India got independent and in 1950 onwards, when the constitution was enacted. You have to understand the process of appointment initially in the past 3 decades or so after the enactment of constitution went very smoothly, because government had followed a convention that the senior most judge of High Court or Supreme Court will be appointed as the Chief Justice of India in case of Supreme Court and Chief Justice of a particular High Court in cases of High Court. So this was the convention that was followed by the government, that the senior most justice would be appointed eventually by the government as the Chief Justice of India or Chief Justice of a particular High Court. So seniority was given preferences over the other factors, and this went smoothly until 1973. In 1973, what happened, that Mrs. Indira Gandhi was the Prime Minister of India, and she superseded 3 senior most judges to appoint Justice A.N. Ray as the next Chief Justice of India. So she superseded 3 senior most judges to appoint another justice as the Chief Justice of India, and this tilted the favor of appointment in favor of executive. Now executive was deciding who to appoint, who not to appoint. So the harmonious relationship between judiciary and executive in terms of appointment got disturbed because Mrs. Indira Gandhi chosen to appoint the 4th senior most judges, not the most senior most judges of the Supreme Court, as the next Chief Justice of India. Similarly, in 1977, she appointed the 2nd senior most judge as the new Chief Justice. So this made sure that the judiciary now thought that the primacy of the executive is not okay. Judiciary should take the matters in their own hands when it comes to appointment to the Indian High Court and in the Supreme Court is concerned. So therefore, a series of judgment was passed by the Supreme Court of India. In 1981, the first judge's cases, officially known as SP Gupta versus Union of India case, the word consultation, which is given in Article 124 and 217, here the Supreme Court highlighted that consultation just means asking opinion of the judges of High Court and Supreme Court. The word consultation just means consultation, and the opinion given by the judges of High Court and Supreme Court in this case will not be binding on the government. So this meant that whatever decision the executive made was prevailed over the decisions of judiciary when it came to appointment. But this equation got tilted with the second judge's cases known as Advocates on Record Association versus Union of India. Here the Supreme Court in its judgment said that the word consultation means the concurrence or permission of judiciary. That government of the day can't ignore what the judiciary is saying, and whatever judiciary is saying is binding on the government when it came to appointment of judges of High Court and Supreme Court. And when it comes to seeking the consultation of Chief Justice of India, here the opinion of Chief Justice of India alone would not suffice. Rather, Chief Justice of India should also take the opinion of the 2 senior most judges of the Supreme Court. So technically in the second judge's case, this became the Collegium of India, that is Supreme Court Chief Justice of India and 2 senior most judges of the Supreme Court. Now further in the third judge's cases, that was in 1998, Supreme Court again changed this particular decision and said that the word consultation, it meant concurrence. But when it comes to seeking the opinion of or consultation of the Chief Justice of India, here Chief Justice of India will consult 4 senior most judges of the Supreme Court when it comes to appointment of the judges of Supreme Court, and when it comes to appointment of the judges of High Court, here Chief Justice of India will consult the opinion of 2 other senior most judges. So this became the size of the collegium now, that for appointment of Supreme Court judges, CJI will consult 4 other senior most judges, whereas appointment of High Court judges are concerned, here Chief Justice of India will consider the opinion of 2nd or 2 senior most judges. So this is the present size of collegium as far as judicial appointments is concerned. Now this system of governance again made that the primacy of judiciary remained in the process of appointment to the High Court and Supreme Court. That executive only played the role of administrative role, that it did the paperwork, but the final decision who to appoint, when to appoint, it was the prerogative of the judiciary. Now over the years, this collegium system has come under the criticism for being opaque and unaccountable. Why? because you see in India there is a separation of power, but with separation of power there is also a system of checks and balances. For example, members of legislature, that is few members of the legislature, go on and become the ministers and eventually the prime minister and chief ministers of India or for a state. So naturally these members or the government of the day, they are accountable to the legislature. Similarly, any legislation or law passed by the parliament or state legislature or any executive action, they are reviewed by the judiciary. So this is called systems of checks and balances. But when it comes to appointment of judiciary, here you saw the representation and the concurrence of judiciary is much that legislature and executive, they have no role to play. Therefore this collegium system has invited the accusation of being opaque and unaccountable. Now to change this allegation, in August 2014, Parliament of India, when new government was in place, it passed Constitution or 99th Amendment to the Indian Constitution, and also another act was enacted known as National Judicial Appointment Commission Act of 2014. Now these two changes, it provided for an independent commission, a constitutional body to appoint judges to the Supreme Court and High Court, replacing the collegium system altogether. And in terms of political consensus, this amendment of the Indian Constitution saw political consensus from across all the spectrum of Indian politics. For example, this Constitutional Amendment Act needed to be passed for more than 50% of the legislature, and eventually it was passed by 16 legislature in India, which were not just ruled by BJP but also ruled by left parties and also by Congress. So you can say that this changes to the Constitution saw a wider political participation and consensus from all the political parties. Now what happened, that this matter reached the Supreme Court of India, that this 99th Constitutional Amendment Act, it expanded the ambit of Article 124 to create a constitutional body known as NJAC, which replaced eventually the collegium system. Now this NJAC will decide who to appoint as the judges of Supreme Court and High Court, and it will comprise of the Chief Justice of India, who will act as the chairperson of NJAC, two senior most judges of Supreme Court as ex officio members. So these three are the representatives of judiciary. Understood? Now other three members, it includes the Union Minister of Law and Justice and two eminent persons from civil society who will be nominated by a committee comprising of Chief Justice of India, Prime Minister of India and the leader of opposition in Lok Sabha. And one of these two eminent person has to be a member of scheduled caste, scheduled tribe, OBC, or a minority or a women community. So you can say 3 members are from judiciary, whereas 3 members are non-judicial members, which also includes one minister, that is Minister of Law and Justice. So this in a way tilted the scale of appointments. Earlier judiciary has the sole role on how to appoint, who to appoint. Now judiciary only had the partial role. The other role was shared by the members of civil society and also by a member of executive. So this actually changed the way how the judicial appointments was made through NJAC. Now this law also stated that the criteria of appointment would include not just seniority but also other considerations like regional representation, performance of the judges, etc. And this NJAC Act, which was a supporting legislation to the 99th Constitutional Amendment Act, it empowered that any 2 members of the NJAC, if they decide against the decision taken by NJAC, they can veto a recommendation if they did not agree with it. So technically 2 members out of these 6, they can veto a decision, and by their permission this decision will not be prevailed. So this question of veto eventually that created a controversy of whether this law is constitutional or not, and this matter reached the Supreme Court of India. Now in this case, the Supreme Court of India actually remarked that in context of working of the constitution, the dominant role of executive in appointment of judges, it adversely affected the independence of judiciary. It was commenting on NJAC because NJAC included 3 judicial members plus 3 non-judicial members. So it said that this was actually a dominant role of executive which actually adversely affected the independence of judiciary, and the judiciary is assigned in a democratic country like India an important role of upholding the rule of law and democracy, and its independence and power of judicial review, it is a part of basic structure of the constitution. Where did basic structure of the constitution evolved? It was evolved from the Keshwananda Bharti case in 1973. Now primacy of judiciary in appointment of judges is part of basic structure. So any attempt by the government or any attempt by the legislature to change this basic structure will be invalidated by the Supreme Court of India through the power of judicial review. Now, in the ruling which was passed by the Supreme Court of India, it stated that the judiciary has to be independent and it was necessary that its primacy in appointment of judges stay as it was before the enactment of NJAC. So, any law that would violate this basic structure of the constitution would naturally be unconstitutional and void. So, this became a very touchy topic, and therefore the Supreme Court of India invalidated this very law, highlighting that this was unconstitutional and void. Why? Because it affected the independence of judiciary, and according to Supreme Court of India, independence of judiciary is what? It is the basic structure of constitution, and law passed by parliament or any executive action can't undo the basic structure of the constitution. Now the question is this veto was actually the reason why this law was invalidated? In this regard, many experts have said that had government not been insistent on having a veto against the judges, this amendment might have passed the muster of the judiciary. That in case this a veto would not have been placed, the judiciary would have actually said that this law was constitutional. Also, another issue was the apprehension of a 3-3 dreadlock within the NJAC. What if 3 members of judiciary were adamant on appointing a particular person to the Chief Justice or as a judge of Supreme Court, and the 3 other members would have been against it? So, what would happen in that case? There was no provision in that case such as a casting vote. So, in that case, if the CJI had the casting vote, this would have allowed the predominance of judiciary in cases of a deadlock, and this would have been passed in the Indian Parliament. So these are the discussions that are going on in the newspapers these days of whether or not we should bring back NJCs. What do you think? Please do let me know in the comments. Baga Spinks, Lydia, Yashi, Augustine, Suraj, Niranjan, Kusum, good evening. Soma Mukherjee, Rai Thakur, Sandipan. Okay. Kusum Banjare, very good evening after a long time. You're asking me or you're telling about yourself? Now let us move to the second article of the day. This article appeared in today's newspaper on page 9, and it states that ex-ED chief has been appointed as a permanent member of the or a full-time member of the Economic Advisory Council of the Prime Minister of India. So in that regard, this Economic Advisory Council becomes important from our today's discussion. Now, this Economic Advisory Council of the Prime Minister, it is a body constituted to give advice on economic and other related issues to the Government of India and particularly to the Prime Minister of India. Now, what is the nature of this body? This body is not a constitutional body because again, it was not passed by a particular provision of the Constitution. It is not a statutory body even. It was not passed based on a legislation passed by Indian Parliament. It is a non-permanent body that it can be dissolved anytime if the Prime Minister wishes so, and it is an independent body. It does not belong to any other ministry. It functions separately just as an advisory body to the Prime Minister of India. Now, what is the membership of this body? It consists of a chairperson and several full-time and part-time members. So, the current ED or the ex-ED head was appointed as a full-time member to this particular Economic Advisory Council. Now, the question might be, what this Economic Advisory Council actually does. Now, the term of reference of this Economic Advisory Council to the Prime Minister, it includes that it analyzes an issue, be it economic or otherwise, referred to it by the Prime Minister of India, and therefore it advises the Prime Minister of India on such issues which has been referred to it. Also, it addresses issues which is of macroeconomic importance. What is macroeconomic importance issues? Growth, employment, inflation, and other factors which is necessary for the growth and development of economy, and it presents the views of the council to the Prime Minister, and this matter of macroeconomic importance can be referred to the Prime Minister, to this body, and it can also be considered by this particular council on its own. That is, it has suo motu powers to consider any issue which is ongoing in the Indian country. Now, attending to any other task that has been desired by Prime Minister of India is also one of the responsibility of this body. Understood? You have any doubt? How is life, Guruji? Well, my life, you can see me daily. Good evening, Shweta. Now, with reference to Economic Advisory Council to the Prime Minister, consider the following statement. It is a statutory body constituted to give advice on economic and related issue to the Prime Minister. The body can present its views on addressing issues of macroeconomic importance only on the reference from the Prime Minister. So, please let me know the correct answer. Sarang, Bagaspinks, Yashi, Augustine, Suraj, Niranjan, Kusum, Shweta, Soma. What is the correct answer to this question? Sarang, as usual, the first one says option B. Any another answer? What is my opinion on what? Soma? Shweta says option D, Madison says B, D. Well, first is incorrect. It is not a statutory body. So, second one, this body can present views on addressing issues of macroeconomic importance from the reference of Prime Minister, and also it has a suo motu power that it can consider any matter on its own also, right? So, therefore, second statement also is incorrect. Only the reference from the Prime Minister is incorrect. Also on the reference of Prime Minister would have been the correct option, right? So, both of the answers, both of the statements are right. We have to identify correct option. Therefore, neither 1 nor 2 is the right answer. Now, let us move to the third article of the day. Here, it has stated that the government has notified the revised criteria for classifying the micro, small and medium enterprises. Now, you understand in the union budget, which was presented by Madam Finance Minister on February the 1st, this year, that is the union budget for 2025 and 26, here Madam Finance Minister highlighted that the government has decided for a revised criteria on classifying the MSMEs, that is micro, small and medium enterprises. Now, you understand, since 2020 onwards, the criteria to classify MSME, it presents a similar criteria for both service-based and manufacturing-based MSMEs based on two factors, that is their turnover and also in their investment criteria. So, let us consider or let us understand what is or how is this criteria being revised. Now, for micro enterprises in terms of investment, the criteria early was that for less than 1 crore rupees of investment every year, the companies would have been classified as micro enterprises. Now, this has been revised to 2.5 crore rupees. Understood? Similarly, for small medium enterprises, if the enterprises saw an investment between 1 crore and 10 crore rupees every year, these were classified as small enterprises. Now, this has been increased to 25 crore. Similarly, between investments between 10 to 50 crore, that company would have been called as medium enterprises. This has been increased to 125 crore. So, overall, the criteria has been increased by 2.5 times for all these three types of enterprises. Now, let us understand how the turnover criteria has been increased. For micro enterprises, if their turnover were less than 5 crores rupees every year, then they would have called micro enterprises. Now, this has increased to 10 crore rupees. Similarly, for small enterprises, this was earlier between 5 to 50 crores of turnover, they would have been called as small enterprises. Now, this has been revised to 100 crore. And similarly, for medium enterprises, earlier they had to have the turnover between 50 to 250 crores. Now, it has been increased to 500 crore. So, all in all, in terms of turnover, you have seen this has witnessed increase of 2 times from the last revision. So, this is how both for criteria for investment and turnover has been increased by 2.5 times and 2 times respectively for all these three criteria of enterprises. So, this is how government has allowed for more companies to be classified as medium, small and micro enterprises. Now, let's see what are the benefits that are available to these MSMEs in general, particularly that were announced in this year's budget. Now, you understand, securing finances, particularly from a formal sector that are banks and NBFCs, it is quite a difficult task for MSMEs because they do not have a very sound financial health. So, in order to make it easier for them to secure formal financing, that is loans, to expand their factories, to expand or bring more new modern machineries, a credit guarantee cover has been announced for micro and small enterprises. What is credit guarantee cover? Government is saying to the financial institutions like banks and NBFCs that do not worry, please extend loans to MSMEs. In case for God forbid some reason they are unable to repay back the loan, government is saying I will compensate to the banks and NBFCs. So this is how credit guarantee covers function. The government is saying do not worry, extend them the loan. In case they do not return it back, I will pay you back the same amount against the loans which are not provided to the MSMEs. So this has been enhanced. Earlier it was available till 5 crore rupees. Now it has been enhanced to 10 crore rupees. So technically larger loans will be available to the MSMEs, particularly under the credit guarantee provided by the government. Similarly, you see, earlier farmers were having the problem that they were not able to get finances, particularly for their day-to-day working. So government solved it by providing them the Kisan credit card. Similarly, a customized credit card will also be provided to the micro enterprises, that is 10 lakh micro enterprises will be provided with a customized credit card, which will enable them to get credit cover for about 5 lakh limit. And these will be available only to micro enterprises who are registered on the Udyam portal. So these Udyam portal are the portal where MSMEs have to register in order to get the government benefits. Also, many MSMEs, we have seen MSMEs in general, they are responsible for 45% of our total exports. So in order to promote exports for India, financial health of MSMEs is quite important, and we also have to encourage more MSMEs to participate in the export sector. So for that, export promotion mission was announced by the government, which facilitates easy access to export credit, and it also supports MSME to tackle non-tariff measures in overseas market. We see many developed markets like European Union, they impose non-tariff measures like sanitary, phytosanitary measures, quality measures, and all of these requires some kind of a financing for the MSME so that they can get their product tested and have the certificates which will allow them to send their products into other markets. So for that, export promotion mission has been announced. Also, new MSMEs, particularly startups, they will be funded by a new fund of funds which will have the corpus of 10,000 crore rupees. Also, we see that there is a scheme for traditional artisans who manufacture their items and sell them to another markets, and for that scheme for fund for registration of traditional industries, Sfurti scheme has been introduced. Also, a Prime Minister's Employment Generation Program has been announced, which is a credit linked subsidy scheme for providing employment opportunities through establishment of micro enterprises in the non-farm sector. Now understand, in total number there are 11 crore of MSMEs, and they are responsible for about employing 20 crore of Indian workforce, which is a huge number. So in order to make them formalized and in order to have them much better in their capacity, we can technically generate more employment in this sector. So this is how government is trying to encourage employment in the MSMEs. So this is how many kind of benefits are available to all the people in MSME sector. Now let's see if you are able to solve this question quickly. Good evening, Rishabh. You always join in the middle of the session. Why is it so? Answer quickly. Soma says option C. Well, investment limit for micro enterprises has been increased from 1 to 2.5 crore. Turnover limit for small enterprises has been doubled from 50 to 100 crore. Investment limit for medium enterprises has been raised from 50 to 150 crore. Which one is the correct answer? Sarang says option A. Soma says option C. Well, third for sure is incorrect, as we have seen that the investment limit has been increased by 2.5 times, right? And this has increased from 3 times. So how is this correct? Incorrect, obviously. And if third one is incorrect, you can safely eliminate the right answer. Option A is the correct one. Understood? So this is how you solve the question. Now, like every day I tell you, MSMEs are an important part of Indian economy. What is the importance of MSME, particularly from sectoral perspective? We try to understand this to our students in our foundation batches. And why in foundation batches? Because it allows about 150 hours of special dedicated class just for economy. Similarly, other subjects have their respective weightages also. And these kind of education are very important if you have to attempt your UPSC exam, because clearing not just UPSC but other exams are also very important. So how do you register for courses? Make sure to explore, click on explore courses, go to courses that are available for UPSC IAS English, click on this tile which highlights P2I foundation batches for 2025, click on buy now. Now as soon as you click on buy now, you have to create an account, and after creating an account you can see there will be an option to add promo code. Please add promo code and write the code which is known as ATS Live. This code must be flashing now on the bottom half of your screen, right? So use the code ATS Live. You will get much more discount, even more than 30. Currently, you can see this is available at 37,499. But with the use of this discount, you can get this money available right now, or the course fees will reduce to 29,999 rupees. Understood? And this will be only be applicable if you use the code called as ATS Live. Okay. So this is how you get maximum discounts on the courses that are available on our platform. Now let us move to the next article of the day. This next article appeared in yesterday's newspaper. Actually, because of paucity of time, I left out this article. Now I am taking this today. This appeared yesterday on page 16, and it states that Russia and Ukraine have agreed on safety of shipping that goes through the water body of Black Sea, right? So in addition to having a safety of shipping in Black Sea, they have also agreed on not to attack each other's energy infrastructure. Now this agreement was reached when a US brokered deal happened in Riyadh of Saudi Arabia. So let us understand some of the details about this water body which is in news, that is Black Sea. Now as you can see from this map, this is the Black Sea which borders many other countries. Now important water bodies which are located very close to Black Sea is towards southwest. This is a Sea of Marmara, and Black Sea is connected with Sea of Marmara through this passage known as Strait of Bosphorus. Understood? Similarly, when a ship navigates from Black Sea through Bosphorus Strait into Sea of Marmara to enter Aegean Sea here, it has to enter this particular water body or narrow passage of strait known as Dardanelles Strait. Understood? Similarly, when you go north of Black Sea, this is the Sea of Azov which is located here, and this area is known as the Crimean Peninsula. Understood? So this area is the Crimean Peninsula which was annexed by Russia in the year 2014. Now connecting the Sea of Azov with Black Sea is a strait known as Kerch Strait. So these are the important water bodies that you have to remember. Sea of Marmara, connecting with Sea of Marmara, this is called Strait of Bosphorus. Connecting Black Sea with Sea of Azov is Kerch Strait, and connecting Sea of Marmara with Aegean Sea is the Dardanelles Strait. Understood? Now let us take a few details about the water body called as Black Sea. It is a large inland sea located between Eastern Europe and West Asia. It connects to the Mediterranean Sea via the Bosphorus Strait. As you can see, Bosphorus Strait is here, and the most popular location on the Bosphorus Strait is the city of Istanbul, which is quite famous for its tourism spot. Also, there are other bodies known as Sea of Marmara, and connecting Sea of Marmara with Aegean Sea is the Dardanelles Strait, as I have already told you. Now, countries which are bordering Black Sea becomes very important from the MCQ perspective. So, these are Turkey, Bulgaria, Ukraine, Russia, Georgia and Romania. I'll tell you a simple mnemonic to remember these countries. It is known as T, that is Turkey, Bulgaria, Ukraine, Russia, Georgia and Romania. So this abbreviation becomes T-Burger. Okay. Now the rivers which are draining into the Black Sea, it is also important because we see last year in Red Sea the question appeared on which rivers are draining into Red Sea. So these are Danube, Dnieper and Don. So these are the three rivers or prominent ones that are draining into Black Sea, and the countries bordering this Black Sea is T-Burger, that is Turkey, Bulgaria, Ukraine, Russia, Georgia and Romania. You'll remember this mnemonic. Now let's see if you are able to solve this question. Consider the following countries. How many of these five share their coastline with the Black Sea? Please do answer this quickly. Anyone? Well, I told you the abbreviation to remember this is T burger. So Turkey, Bulgaria, it's there. Ukraine, Russia, not there. Georgia, it's there. R is Romania, it's there. So third and fifth is not. 1, 2, 4 is the right answer. So only 3, option B is the right answer. Niranjan, Yashi, Soma, yes. All of you are correct. Now let's move to the next article. Rushikonda Beach in Visakhapatnam wins back the blue flag tag. Now Rushikonda Beach, located in Visakhapatnam of the Andhra Pradesh state, it has won back the blue flag tag which was earlier withdrawn due to the poor maintenance. Now I've attached a screenshot of all the beaches in India which have gotten the blue flag certification. These are about 12 beaches in India. As you can see, all of them are present in Lakshadweep, Andaman Nicobar Island, and also in the eastern and western coast. That is, in Gujarat there are 2 spots, in Maharashtra there are none, in Karnataka there are 2, in Kerala there are 1, similarly 1 each in Puducherry, here in Tamil Nadu, Rushikonda, Golden, and also in Andaman and Lakshadweep Island. So total there are 2 beaches which have the blue flag certification. Now this blue flag certification is an international eco label which is awarded by an NGO known as Foundation for Environmental Education. This is a Denmark based NGO. Now it is given not just to beaches but also to marinas and sustainable boating tourism operators that meet the high environmental safety and cleanliness standard. Now the basis based on which this certification is provided, that it is provided after this beach or any tourism spot fulfills 33 stringent criteria which is spread across 4 major categories: environmental education and information, water quality, environmental management, and safety and services. And in total India has 12 blue flag beaches who are certified as a blue flag beaches in 2024. Understood? Now let's see if you are able to solve this question. With reference to blue flag certification, consider the following statement. The blue flag certification is awarded by the UNEP. Incorrect. Blue flag certification is given when a beach fulfills stringent criteria across 4 major categories. This one is correct. Till date, Rushikonda is the only beach that has received the blue flag certification in India. This is incorrect. I have told you, till date there are 12 beaches who have received the certification. We have to identify correct one. Only 2 is correct. 1 and 3rd is incorrect. Sorry for this option. Here 1 only will be the right answer. Okay. So option A is the right one. Sorry for this mistake. I should have changed this. I forgot to change it. Now let us move to the last article of the day. This article actually appeared in yesterday's paper. It told us about injustice unchecked. In general, this article talks about the phenomena of bulldozer justice that we have seen quite prominent in states like Maharashtra, Uttar Pradesh, Rajasthan, Madhya Pradesh, etc. Now, the context of this article was that in recent years we have seen an increasing trend of state governments using bulldozers to demolish the properties without due process being followed, and this is popularly known as bulldozer justice. Now, most recently, the Municipal Corporation of Bombay, that is Brihan Mumbai Municipal Corporation BMC, it demolished an unauthorized shed linked to the comedian Kunal Kamra because he made certain comments in his comedic show. Now, what is bulldozer justice, also known as extra legal demolitions? Now it is referred to an instant justice mechanism that is propagated by governments of various states to punish alleged rioters, protesters, perpetrators of serious crime by razing down their houses, stalls and any construction using a JCB machine. Now the legal legality of this move, actually, that the state government officials assert that demolition is justified under municipal laws either on account of action against an encroachment or under the pretext of unauthorized construction. So the state government officials or the municipal corporation officials, they say that they are demolishing only those structures that have been unauthorizedly constructed or they are encroaching upon the public or government based lands. Now, for example, UP Municipal Corporation Act and the UP Urban Planning Development Act were used to carry out demolitions in the state of UP. Similarly, in other states also, such acts have been used to provide a legal background to this kind of a move by the government. Now, let us understand why does government follows this kind of a motive or this kind of a move to deliver instant justice. First of all, it helps government to maintain public order and deterrences, because it puts the fear of law in the minds of hardened criminals, that they understand by their doing of crime, not just they are affected but also their families are in danger, because they will lose their shelters over their head. So this can actually deter people from indulging in criminal activities. Also, it helps government to restore order quickly, because demolishing the illegal properties of those accused in communal conflicts has helped government restore order in East Tension. For example, when violence happened in New district of Haryana, government enacted quickly to demolish the illegal structures of the people who were accused in this communal incident, and with this measure we saw the communal tensions that were present in the No, it abated quite quickly. Also, government says that it has a very clear intent, that the demolition, they are not aimed at any special groups or properties who are affected by people of similar community, but it is intended only to clear encroachment that have prevailed over the recent years, and it is also seen as a way to free up the encroached public land. For example, in UP, it has helped the revenue department of the UP government to free around 67,000 acres of land from land mafia, which were eventually used for other purposes like promoting sports based activities. So this is how government is using these kind of to have many reasons. But let us now quickly understand what are the issues that are there with delivering of such instant bulldozer justice. First is that there are allegations that the government is not following the due process of law, which also forms the part of Article 21 of the Constitution as per the Supreme Court judgment in the Maneka Gandhi says. Now, in such cases, the Supreme Court has highlighted that law should take the own course of land, that in case of violation of the law, the government should actually send the notice to the accused highlighting that this is the law they have violated. It should give the accused the time to explain his or her says, allow them to approach the court of the land, and then accordingly the government should make their move. However, bulldozing alleged illegal properties of crime accused without serving notice is a violation of the due process of law, which was upheld by the Maneka Gandhi case. And also, there is a principle of natural justice that you can't punish anyone without hearing their side of the argument, and this is called as principle of natural justice. So without hearing them their side of the argument, without serving them the notice, this also violates the principles of natural justice. Also, it is also against the separation of power. I told you, executive, that is the bodies like police, etc., they are only responsible for investigation of the crimes. With their investigation, they should file a report to the courts, and it is ultimately the courts and judiciary of India that is responsible for punishing a criminal based on the investigative report by the police and other law enforcement authorities. But when executive itself, they are delivering the punishment through this bulldozer justice, it violates the separation of power, that accused must be proved accused before a court on law, and then only the punishment should be given by the judiciary, not by the executive action. And by giving punishment by the executive themselves, it also highlights that the executive themselves, they do not have the trust on the criminal justice system of India, because eventually it is the job of criminal justice of India or criminal justice system like courts to give punishments to the criminal, not the government or executive. Also, there are other issues with bulldozer justice, is that it is alleged that these kind of instances, they target only specific groups. Also, in terms of constitution, there is a double punishment for the same crime. For example, the person who has been accused of crime will eventually be given punishment by the judiciary. However, if government is demolishing their homes, their offices, their businesses, it is also a kind of double punishment, which violates the Article 20 subsection 2 of the Indian Constitution, that prohibits double jeopardy, right? That no person can be prosecuted and punished twice or more than once for a same offense that they commit. And punishing the guilty again through demolition goes through the spirit of the fundamental right that protects against double jeopardy. Also, right to property in India is a constitutional right which can only be taken away by an authority of the law. And as this is an extra legal measure, so it violates also the right to property of an individual, which is a constitutional right. So these are the issues that are there with bulldozer justice. We understand that government is wanting to achieve something, but is this the right way to achieve something? According to these arguments, these are not. Now let us understand what is the way forward. Should government stop these demolition drive, or should these demolition drive continue with added protection measures? So in this regard, the government and the courts and the experts have highlighted that we need to have a pre-demolition survey and an advance notice that should be given before these demolition drives should happen. That SC has directed that a survey must be conducted before any such demolitions take place, and the authorities must adhere to the basic procedural protocols, which includes providing sufficient advance notice so that people who get these notice, they can approach to higher courts and they can also have the sufficient time to take their belongings out of that house or that particular property. Also, a national guideline on demolition procedures were created, and it should be integrated into the local municipal laws and regulation so that it ensures that a correct procedures are adhered to at every stage of the demolition process, that is before demolition, during demolition and after the demolition take place. And also we need a stricter legal adherence before demolition. It is essential as highlighted by the Supreme Court in the Olga Tellis case. In Olga Tellis case, Supreme Court highlighted that having a home, it is very a part of right to privacy under Article 21. It is a part of right to shelter, and demolishing these homes or offices, they actually do away with your right to privacy, right to shelter, right to earn a livelihood. Understood? Also, the burden of proof for this demolition should be put on authorities so that authorities will be able to protect human rights of shelter, which has also been recognized by Supreme Court as a part of fundamental right in Chameli Singh versus State of Uttar Pradesh case. And also independent oversight mechanism, that is a committee of judges and civil society members should be formed to check if the proposed demolitions are legal. And also reformation should be aim of the criminal justice system, not delivering the punishment. That in a democratic society, our focus should not be on taking revenge or seeking retribution, but rather on reforming the person, and such actions can actually increase the process or increase the probability that that particular accused will not be reformed. So this is our best interest in a society, that although these demolitions can continue, but these should be continued with an added safety mechanism. That is, people who are not deserving these kind of punishments and also the family members of the accused, they have more or less no role in the acts done by the same family member who is accused of committing a crime. So why should the family have the burden, or why should family pay the cost of such kind of a measures? So this is what today's argument is all about. Please do attempt the question. I see the number of students who are attempting these questions have reduced drastically. I will still encourage you, if you find even half hour of your time, please do write the answers and submit it to me, and I will check the answers which are submitted to me before 8 p.m. and you can submit your answers on this particular Telegram group, that is ATS Live. So this is all from my side for today. I will see you again tomorrow at 4. Until then, please keep reading, keep analyzing, and more importantly, keep writing your answers.